I agree with my brother on the points that he's made, and I want to emphasize, as he stated, that Invenergy made the choice to enter into a non-binding letter of intent with Pascoag Utility District and operated under that letter until it was terminated, which was the Pascoag Utility District's right. If Invenergy wanted to lock up the right to use that well, it should have done so in a binding contract. So it needs to suffer the consequences of its own actions in choosing to go the non-binding letter of intent route. And it should not be heard to complain here today that this occurred late in the process. Secondly, I respectfully disagree that we're not late in the process. And the reason I say that is because all of the advisory opinions are in. All of them. Including the advisory opinions of the planning board, the zoning board, the building inspector, and the tax assessor from the town of Borough, which were conducted and concluded at significant expense, not only to the town, but the investment of time of its residents to participate in those hearings. I would assume that if this board chooses to elect the suspension process, and if they in fact come forward with a water plan, that would then require us to go back to not just the town boards, but the state boards and agencies, etc., and have all new hearings. Again, at great expense. Simply because Invenergy chose to go the non-binding letter of intent. They should not be allowed to profit on their own mistake. Mr. Shore has argued that it would contribute to efficiency to go with the suspension rather than the dismissal, because they will just simply refile again, and we'll be back before this board doing it all over again. Well, maybe Mr. Shore did not hear me when I quoted the statute that gave this board its options when a filing is non-compliant. And again, that is 4298-16A. Non-compliance shall constitute grounds for suspension or dismissal with or without prejudice in its discretion. If you dismiss with prejudice, they will never come back. Now, of course, you know it's our position, and we hold to our position that this matter should be dismissed with prejudice. However, if this board is inclined to give them any period of time at all to come up with a water plan, then I would strongly suggest that it not be by way of a suspension, but done exactly the same way it's done every single day on the motion calendar in Superior Court. And that's with a conditional order of dismissal. The court will enter a conditional order. It will give a party a certain period of time to comply with that order. And if there is no compliance with that order within that period of time, the case is automatically dismissed. I think that's judicial economy, that's administrative economy and efficiency, and that's what this board should do at a minimum. I am not suggesting it. I'm suggesting a dismissal with prejudice. But if you choose to go and give them additional time, it should be in the form of a conditional order of dismissal with the penalty for failure to comply, dismissal. Finally, I need to make a point, a legal point for the record. We talked about the tolling provision in the board's rules. I need to point out there is no tolling provision in the Act. None whatsoever. There is a suspension statute. It says nothing about tolling. It is the board's rules that say that the board believes it can toll the time periods in the statute. The statute has very strict time periods, and they say nothing about the board altering those time periods in its discretion. It is the town's position that the board's rules, which are an attempt to modify the statutory time periods, go beyond the authority of the board to enact rules. A board can enact rules that allow it to do its job in accordance with the statute. A board cannot act rules that override the statute. That's a legal position. I need to make that on the record so that if this matter should go up on appeal, we would have preserved it. So I wanted to make that